size of the print. Okay? You won't get all of these instructions, just the ones that the counsel and I have determined will be the ones that are applicable. Okay? The law requires that I read these instructions to you. We narrowed all of that down to this. Okay? I'm going to read these instructions to you. I'm going to give you the exact same instructions to take into the back when you get started today. Okay? So you can certainly take notes if you wish. I'm going to give you the exact same instructions. And the attorneys will go over the instructions they feel are important with each one. So you'll be very familiar with them by the time you get back there. Okay? So, again, the law requires that I read these to you. I would say it's going to be less than 45 minutes, maybe. Here we go. Number 100 has been given. 101 has been given. 102 has been given. 124. You may be permitted to separate during recess and at the end of the day. I will tell you when to return. Please remember we cannot begin the trial until all of you are in place, so it's important to be on time. Remember, do not talk about the case or about any of the people or any subject involved in it with anyone, including the other jurors. Do not research, share information, or talk to each other or anyone else about the facts of the case or anything else connected with the trial. And do not use any form of electronic or wireless communication to do any of these things either. Do not make up your mind or express any opinion about the case or any issue connected with the trial until after you have discussed the case with the other jurors during deliberation. Members of the jury, I will now instruct you on the law that applies to this case. I will give you a copy of the instructions to use in the jury room. The instructions that you receive may be printed, typed, or written by hand. Certain sections may have been crossed out or added. Disregard any deleted sections and do not try to guess what they might have been. Only consider the final version of the instructions in your deliberations. You must decide what the facts are. It is up to all of you and you alone to decide what happened, based only on the evidence that was presented to you in this trial. Do not let bias, sympathy, prejudice, or public opinion influence your decision. Bias includes, but is not limited to, bias for or against the witnesses, attorneys, defendant, or alleged victim, based on disability, gender, nationality, national origin, race or ethnicity, religion, gender identity, sexual orientation, age, or socioeconomic status. You must follow the law as I explain it to you, even if you disagree with it. If you believe that the attorney's comments on the law conflict with my instructions, you must follow my instructions. Pay careful attention to all these instructions and consider them together. If I repeat any instruction or idea, do not conclude that it is more important than any other instruction or idea just because I repeated it. Some words or phrases used during this trial have legal meanings that are different from their meanings in everyday use. These words and phrases will be specifically defined in the instructions. Please be sure to listen carefully and follow the definitions that I give you. Words and phrases not specifically defined in these instructions are to be applied using their ordinary, everyday meanings. Some of these instructions may not apply depending on your findings about the facts of the case. Do not assume just because I give a particular instruction that I am suggesting anything about the facts. After you have decided what the facts are, follow the instructions that do apply to the facts as you find them. Do not use the internet, a dictionary, or other reference materials in any way in connection with this case, either on your own or as a group. Do not investigate the facts or the law or do any research regarding this case, either on your own or as a group. Do not conduct any tests or experiments or visit the scene of any event involved in the case. If you happen to pass by the scene, do not stop or investigate. You have been given notebooks and may have taken notes during the trial. You may use your notes during deliberations. Your notes are for your own individual use to help you remember what happened during the trial. Please keep in mind that your notes may be inaccurate or incomplete. If there is a disagreement about the testimony at trial, you may ask that the court reporter's record be read to you. It is that record that must guide your deliberations, not your notes. You must accept the court reporter's record as accurate. Please do not remove your notes from the jury room. At the end of the trial, your notes will be collected and destroyed and will not be a part of the case record. It is alleged that the crime occurred on or about March 30, 2014 through November 18, 2014. The people are not required to prove that the crime took place exactly on that day, but only happened reasonably close to that day. 220. The fact that a criminal charge has been filed against the defendant is not evidence that the charge is true. You must not be biased against the defendant because she has been arrested, charged with a crime, or brought to trial. A defendant in a criminal case is presumed to be innocent. This presumption requires that the people prove a defendant guilty beyond a reasonable doubt. Whenever I tell you that people must prove something, I mean they must prove it beyond a reasonable doubt unless I specifically tell you otherwise. Proof beyond a reasonable doubt is proof that leaves you with an abiding conviction that the charge is true. The evidence need not eliminate all possible doubt because everything in life is open to some possible or imaginary doubt. In deciding whether the people have proved their case beyond a reasonable doubt, you must impartially compare and consider all the evidence that was received throughout the entire trial. Unless the evidence proves the defendant guilty beyond a reasonable doubt, she is entitled to an acquittal, and you must find her not guilty. Evidence is the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I told you consider as evidence. Nothing that the attorneys say is evidence. In their opening statements and closing arguments, the attorneys will discuss the case, but their remarks are not evidence. Their questions are not evidence. Only the witnesses' answers are evidence. The attorney's questions are significant only if they help you to understand the witness's answer. Do not assume something is true just because one of the attorneys asked a question that suggested it was true. During the trial, the attorneys may have objected to questions or moved to strike answers given by the witnesses. I ruled on the objections according to the law. If I sustained an objection, you must ignore the question. If the witness was not permitted to answer, do not guess what the answer might have been or why I ruled as I did. If I order testimony stricken from the record, you must disregard it and must not consider that testimony for any purpose. You must disregard anything you saw or heard when the court was not in session, even if it was done or said by one of the parties or witnesses. The court reporter has made a record of everything that was said during the trial. If you decide that it is necessary, you may ask that the court reporter's record be read to you. You must accept the court reporter's record as accurate. Folks, if you do decide that you need readback for whatever reason, try to be as specific as you can for me, okay? Tell me which witness it was you wanted to hear from, which attorney was asking the questions, and what it is you're looking for. If you don't need any readback, perfectly fine. If you do, narrow it in for me, okay? Facts may be proved by direct or circumstantial evidence or by a combination of both. Direct evidence can prove a fact by itself. For example, if a witness testifies he saw it raining outside before he came into the courthouse, that testimony is direct evidence that it was raining. Circumstantial evidence may also be called indirect evidence. Circumstantial evidence does not directly prove the fact to be decided, but is evidence of another fact or group of facts from which you may logically and reasonably conclude the truth of the fact in question. For example, if a witness testifies he saw someone come inside wearing a raincoat, and that raincoat is covered with drops of water, that testimony is circumstantial evidence because it may support a conclusion that it's raining outside. Both direct and circumstantial evidence are acceptable types of evidence to prove or disprove the elements of the charge, including intent and mental state and acts necessary to a conviction. And neither is necessarily more reliable than the other. Neither is entitled to any greater weight than the other. You must decide whether a fact and issue has been proved based on all the evidence. Before you may rely on circumstantial evidence to conclude that a fact necessary to find the defendant guilty has been proved, You must be convinced that the people have proved each fact essential to that conclusion beyond a reasonable doubt. Also, before you may rely on circumstantial evidence to find the defendant guilty, you must be convinced that the only reasonable conclusion supported by the circumstantial evidence is that the defendant is guilty. If you can draw two or more reasonable conclusions from the circumstantial evidence, one of those reasonable conclusions points to innocence and another to guilt, you must accept the one that points to innocence. However, when considering circumstantial evidence, you must accept only reasonable conclusions and reject any that are unreasonable. The people must prove not only that the defendant did the acts charged, but also that she acted with a particular intent or mental state. The instruction for each crime and allegation explains the intent or mental state required. An intent or mental state may be proved by circumstantial evidence. Before you may rely on circumstantial evidence to conclude that a fact necessary to find the defendant guilty has been proved, you must be convinced that the people have proved each fact essential to that conclusion beyond a reasonable doubt. Also, before you may rely on circumstantial evidence to conclude that the defendant had the required intent or mental state, you must be convinced that the only reasonable conclusion supported by the circumstantial evidence is that the defendant had the required intent or mental state. If you can draw two or more reasonable conclusions from the circumstantial evidence, one of those reasonable conclusions supports the finding that the defendant did have the required intent or mental state, and another reasonable conclusion supports a finding that the defendant did not, you must conclude that the required intent or mental state was not proved by the circumstantial evidence. However, when considering circumstantial evidence, you must accept only reasonable conclusions and reject any that are unreasonable. You alone must judge the credibility or believability of the witnesses. In deciding whether testimony is true and accurate, use your common sense and experience. You must judge the testimony of each witness by the same standard, setting aside any bias or prejudice you may have. You may believe all, part, or none of any witness's testimony. Consider the testimony of each witness and decide how much of it you believe. In evaluating a witness's testimony, you may consider anything that reasonably tends to prove or disprove the truth or accuracy of that testimony. Among the factors you may consider are the following. How well could the witness see, hear, or otherwise perceive the things about which the witness testified? How well was the witness able to remember and describe what happened? What was the witness's behavior while testifying? Did the witness understand the questions and answer them directly? Was the witness's testimony influenced by a factor such as bias or prejudice, or personal relationship with someone involved in the case, or a personal interest in how the case is decided? What was the witness's attitude about the case or about testifying? Did the witness make a statement in the past that is consistent or inconsistent with his or her testimony? How reasonable is the testimony when you consider all the other evidence in the case? Did other evidence prove or disprove any fact about which the witness testified? Did the witness admit to being untruthful? Has the witness been convicted of a felony? Has the witness engaged in other conduct that reflects on his or her believability? Was the witness promised immunity or leniency in exchange for his or her testimony? Do not automatically reject testimony just because of inconsistencies or conflicts. Consider whether the differences are important or not. People sometimes honestly forget things or make mistakes about what they remember. Also, two people may witness the same event yet see or hear it differently. If you do not believe a witness's testimony that he or she no longer remembers something, that testimony is inconsistent with the witness's earlier statement on that subject. If you decide that a witness deliberately lied about something significant in this case, you should consider not believing anything that witness said. Or if you think the witness lied about some things but told the truth about others, you may simply accept the part you think is true and ignore the rest. The crimes or allegations charged in counts 1 through 6 require the proof of the union or joint operation of act and wrongful intent. The following crimes and allegations require general criminal intent. Poisoning or adulterating food as charged in count 5. For you to find a person guilty of this crime, excuse me, That person must not only commit the prohibited act, but must do so with wrongful intent. A person acts with wrongful intent when he or she intentionally does a prohibited act. However, it is not required that he or she intend to break the law. The act required is explained in the instruction for that crime. The following crimes and allegations require a specific intent or mental state. Counts 1, 2, 3, 4, and 6, and the allegation. For you to find a person guilty of these crimes or the allegations true, the person must not only intentionally commit the prohibited act, but must do so with a specific intent or mental state. The act and the specific intent or mental state required are explained in the instruction for that crime or allegation. 1 second. Neither you might recall a few weeks ago, either my clerk or my bailiff gave me a cold. Both will be on latrine duty after the interview. Neither side is required to call all witnesses who may have information about the case or to produce all physical evidence that might be relevant. Except for the testimony of Jonathan Hearn, which requires supporting evidence, the testimony of only one witness can prove any fact. Before you conclude that the testimony of one witness proves a fact, you should carefully review all the evidence. If you determine there is a conflict in the evidence, you must decide what evidence, if any, to believe. Do not simply count the number of witnesses who agree or disagree on a point and accept the testimony of the greater number of witnesses. On the other hand, do not disregard the testimony of any witness without a reason or because of prejudice or desire to favor one side or the other. What is important is whether the testimony or any other evidence convinces you, not just the number of witnesses who testify about a certain point. If you find that a witness has been convicted of a felony, you may consider that fact in evaluating the credibility of the witness's testimony. The fact of a conviction does not necessarily destroy or impair a witness's credibility. It is up to you to decide the weight of that fact and whether that fact makes the witness less believable. You have heard evidence of statements that a witness made before the trial. If you decide that the witness made those statements, you may use those statements in two ways. One, to evaluate whether the witness's testimony in court is believable, and two, as evidence that the information in those earlier statements is true. Witnesses were allowed to testify as experts and to give opinions. You must consider the opinions, but you are not required to accept them as true or correct. The meaning of I'm very sorry. You must consider the opinions, but you are not required to accept them as true or correct. The meaning and importance of any opinion are for you to decide. In evaluating the believability of an expert witness, follow the instructions about the believability of witnesses generally. I just gave you that. In addition, consider the expert's knowledge, skill, experience, training, and education, the reasons the expert gave for any opinion, and the facts or information on which the expert relied in reaching that opinion. You must decide whether information on which the expert relied was true and accurate. You may disregard any opinion that you find unbelievable, unreasonable, or unsupported by the evidence. Witnesses who were not testifying as experts gave their opinions during the trial. You may, but are not required to accept those opinions as true or correct. You may give the opinions whatever weight you think appropriate. Consider the extent of the witness's opportunity to perceive the matters on which his or her opinion is based, the reasons the witness gave for any opinion, and the facts or information on which the witness relied in forming that opinion. You must decide whether information on which the witness relied was true and accurate. You may disregard all or any part of an opinion that you find unbelievable, unreasonable, or unsupported by the evidence. In the crimes of counts 1 through 6, strike that. If the crimes of counts 1 through 6 were committed, then Jonathan Hearn was an accomplice to those crimes. You may not convict a defendant of counts 1 through 6 based on the statement or testimony of an accomplice alone. You may use the statement or testimony of an accomplice to convict the defendant only if 1, the accomplice's statement or testimony is supported by other evidence that you believe. 2, that supporting evidence is independent of the accomplice's statement or testimony. And 3, the supporting evidence tends to connect the defendant to the commission of the crime. Supporting evidence, however, may be slight. It does not need to be enough by itself to prove that the defendant is guilty of the charged crime, and it does not need to support every fact mentioned by the accomplice in the statement or about which the witness testified. On the other hand, it is not enough if the supporting evidence merely shows that a crime was committed or the circumstances of its commission. The supporting evidence must tend to connect the defendant to the commission of the crime. Any statement or testimony of an accomplice that tends to incriminate the defendant should be viewed with caution. You may not, however, arbitrarily disregard it. You should give the statement or testimony the weight you think it deserves after examining it with care and caution in the light of all the other evidence. When Jonathan Hearn testified, he was in custody. The fact that a witness is in custody does not by itself make a witness more or less believable. Evaluate the witness's testimony according to the instructions that I have given you. You have heard evidence that the defendant made an oral or written statement before the trial. You must decide whether the defendant made any such statements in whole or in part. If you decide that the defendant made such a statement, consider the statements along with all the other evidence in reaching your verdict. It is up to you to decide how much importance to give to the statements. Consider with caution any statement made by the defendant intended to show her guilt, unless the statement was written or otherwise recorded. The defendant may not be convicted of any crime based on her out-of-court statements alone. You may rely on the defendant's out-of-court statements to convict her only if you first conclude that the other evidence shows that the charged crime was committed. That other evidence may be slight and need only be enough to support a reasonable inference that the crime was committed. This requirement of other evidence does not apply to proving the identity of the person who committed the crime. If other evidence shows that the charged crime was committed, the identity of the person who committed it may be proved by the defendant's statement alone. You may not convict the defendant unless the people have proved her guilt beyond a reasonable doubt. If the defendant made a false or misleading statement before this trial relating to the charged crime, knowing the statement was false or intending to mislead, that conduct may show she was aware of her guilt of the crime, and you may consider it in determining her guilt. If you conclude that the defendant made the statement, it is up to you to decide its meaning and importance. However, evidence that the defendant made such a statement cannot prove guilt by itself. The people are not required to prove that the defendant had a motive to commit any of the crimes charged. In reaching your verdict, you may, however, consider whether the defendant had a motive. Having a motive may be a factor tending to show the defendant is guilty. Not having a motive may be a factor tending to show the defendant is not guilty. If the defendant tried to create false evidence, that conduct may show that she was aware of her guilt. If you conclude that the defendant made such an attempt, it is up to you to decide its meaning and importance. However, evidence of such an attempt cannot prove guilt by itself. A person may be guilty of a crime in two ways. One, he or she may have directly committed the crime. I will call that person the perpetrator. Two, he or she may have aided and abetted a perpetrator who directly committed the crime. A person is guilty of a crime whether he or she committed it personally or aided and abetted the perpetrator. To prove that the defendant is guilty of a crime based on aiding and abetting that crime, the people must prove that 1, the perpetrator committed the crime. 2, the defendant knew that the perpetrator intended to commit the crime. 3, before or during the commission of the crime, the defendant intended to aid and abet the perpetrator in committing the crime. And 4, the defendant's words or conduct did in fact aid and abet the perpetrator's commission of the crime. Someone aids and abets a crime if he or she knows of the perpetrator's unlawful purpose, and he or she specifically intends to and does in fact aid, facilitate, promote, encourage, or instigate the perpetrator's commission of that crime. If all these requirements are proved, the defendant does not have to have actually been present when the crime was committed to be guilty as an aider and abetter. If you conclude that the defendant was present at the scene of the crime or failed to prevent the crime, you may consider that fact in determining whether the defendant was an aider and abetter. However, the fact that a person is present at the scene of the crime or fails to prevent the crime does not, by itself, make him or her an aider and abetter. Everybody with me? Antenna out, paying attention? Homicide is the killing of one human being by another. Sir. One second, Mr. Terry, you might be right. One second, please. See counsel a sidebar for 1 second. Reflect that Mr. Terry is correct. The way the paragraph reads, there are two very separate. Doesn't matter. Here we go. All right. I'll read the last part of 401. However, the fact that a person is present at the scene of a crime or fails to prevent the crime does not by itself make him or her an aider and abetter. If the people have not met this burden, you may not strike that. If the people have not met this burden, you may not find the defendant guilty under an aiding and abetting theory. Correct, Mr. Terry?
That would be correct, Your Honor.
1 second, please, Floyd. 500. Homicide is the killing of one human being by another. Murder is a type of homicide. The defendant is charged with murder. A homicide can be lawful or unlawful. If a person kills with a legally valid excuse or justification, the killing is lawful and he or she has not committed a crime. If there is no legally valid excuse or justification, the killing is unlawful and, depending on the circumstances, the person is guilty of murder. You must decide whether the killing in this case was unlawful, and if so, what specific crime was committed. I will now instruct you in more detail on what is legally permissible excuse or justification for homicide. I will also instruct you on murder. The defendant is charged in count 1 with murder in violation of Penal Code Section 187. To prove that the defendant is guilty of this crime, the people must prove that 1, the defendant committed an act that caused the death of another person, and 2, when the defendant acted, she had a state of mind called malice aforethought, and 3, she killed without lawful excuse or justification. There is one kind of malice aforethought, which is express malice. Proof of express malice is sufficient to establish the state of mind required for murder. The defendant acted with express malice if she unlawfully intended to kill. Malice aforethought does not require hatred or ill will toward the victim. It is a mental state that must be formed before the act that causes the death is committed. It does not require deliberation or the passage of any particular period of time. Deliberation and premeditation. The defendant is guilty of first-degree murder if the people have proved that she acted willfully, deliberately, and with premeditation. The defendant acted willfully if she intended to kill. The defendant acted deliberately if she carefully weighed the considerations for and against her choice and, knowing the consequences, decided to kill. The defendant acted with premeditation if she decided to kill before completing the acts that caused the death. The length of time the person spends considering whether to kill does not alone determine whether the killing is deliberate and premeditated. The amount of time required for deliberation and premeditation may vary from person to person and according to the circumstances. A decision to kill made rashly, impulsively, or without careful consideration is not deliberate and premeditated. On the other hand, a cold, calculated decision to kill can be reached quickly. The test is the extent of the reflection, not the length of time. The people have the burden of proving beyond a reasonable doubt that the killing was first-degree murder. If the people have not met this burden, you must find the defendant not guilty of first-degree murder. You will be given verdict forms for guilty and not guilty of first-degree murder. As with all the charges in this case, to return a verdict of guilty or not guilty on account, you must all agree on that decision. Follow these directions before you give me any completed and signed final verdict form. Return the unused verdict forms to me unsigned. Number 1, if all of you agree the people have proved beyond a reasonable doubt that the defendant is guilty of the first-degree murder, complete and sign that verdict form. Do not complete or sign any other verdict form for that count. Number 2, if all of you cannot agree whether the defendant is guilty of first-degree murder, inform me that you cannot reach an agreement and do not complete or sign any other verdict form for that count. Number 3, if you all agree the defendant is not guilty of first-degree murder, complete and sign the verdict form for not guilty of first-degree murder. Do not complete or sign any other verdict form for that count. The defendant is charged in count 2 with conspiracy to commit murder in violation of Penal Code Section 182. To prove that the defendant is guilty of this crime, the people must prove that 1, the defendant intended to agree and did agree with Jonathan Hearn to intentionally and unlawfully kill. 2, at the time of the agreement, the defendant and the other alleged member of the conspiracy intended that one or more of them would intentionally and unlawfully kill. 3, the defendant or Jonathan Hearn or both of them committed at least one of the following overt acts alleged to accomplish the killing. Overt act number 1. Jonathan Hearn purchased arsenic trioxide. Overt act number 2. Jonathan Hearn mixed arsenic with pudding. Overt act number 3. Jonathan Hearn delivered the pudding with arsenic to Sabrina Limon's residence in Helendale. Overt act number 4. Sabrina Limon placed the pudding with arsenic into Robert Limon's lunch. Overt act number 5. Jonathan Hearn purchased a cellular phone to escape law enforcement detection. Overt act number 6. Sabrina Limon used the cellular phone provided by Jonathan Hearn. Overt act number 7. Sabrina Limon provided information to Jonathan Hearn of the BNSF shop location in Tehachapi, California. Overt act number 8. Jonathan Hearn went to Tehachapi, California on May 23, 2014 and located the BNF shop based upon information provided by Sabrina Limon. Overt act number 9. Sabrina Limon informed Jonathan Hearn that Robert Limon would be working in Tehachapi, California on August 17, 2014. Overt act number 10. Jonathan Hearn shot and killed Robert Limon on August 17, 2014. And at least one of these overt acts was committed in California. To decide whether the defendant committed these overt acts, consider all the evidence presented about the overt acts. To decide whether the defendant and one or more of the other alleged members of the conspiracy intended to commit murder, please refer to the instructions which define that crime. Just stated. The people must prove that the members of the alleged conspiracy had an agreement and intent to commit murder. The people do not have to prove that any member or members of the alleged conspiracy actually met or came to a detailed or formal agreement to commit the crime. An agreement may be inferred from conduct if you conclude that members of the alleged conspiracy acted with a common purpose to commit the crime. An overt act is an act by one or more members of the conspiracy that is done to help accomplish the agreed upon crime. The overt act must happen after the defendant has agreed to commit the crime. The overt act must be more than the act of agreeing or planning to commit the crime, but it does not have to be a criminal act itself. You must all agree that at least one alleged overt act was committed in California by at least one alleged member of the conspiracy. But you do not all have to agree which specific overt act or acts were committed or who committed the overt acts. Someone who merely accompanies or associates with members of a conspiracy, but who does not intend to commit the crime, is not a member of the conspiracy. Evidence that a person did an act or made a statement that helped accomplish the goal of the conspiracy is not enough by itself to prove that that person was a member of the conspiracy. The defendant is charged in count 3 with soliciting another person to commit a crime in violation of Penal Code Section 653F. To prove that the defendant is guilty of this crime, the people must prove that 1. The defendant requested or asked or invited another person to commit or join in the commission of the crime of murder. And 2, the defendant intended that the crime of murder be committed. To decide whether the defendant intended to commit, strike that. To decide whether the defendant intended that the person commit murder, please refer to the separate instructions that I will give you on that crime. The crime of solicitation must be proved by the testimony of at least 2 witnesses or by the testimony of 1 witness and corroborating evidence. Corroborating evidence is evidence that 1 tends to connect the defendant with the commission of the crime, and 2 is independent of the evidence given by the witness who testified about solicitation or independent of the facts testified to by that witness. Corroborating evidence need not be strong or even enough to establish each element by itself. Corroborating evidence may include the defendant's acts, statements, or conduct, or any other circumstances that tends to connect her to the crime. A person is guilty of solicitation even if the crime solicited is not completed or even started. The person solicited does not have to agree to commit the crime. The defendant is charged in count 4 with attempted murder. To prove that the defendant is guilty of attempted murder, the people must prove that 1, the defendant took at least 1 direct but ineffective step toward killing another person, and 2, the defendant intended to kill that person. A direct step requires more than merely planning or preparing to commit murder or obtaining or arranging for something needed to commit murder. A direct step is one that goes beyond planning or preparation and shows that a person is putting his or her plan into action. A direct step indicates a definite and unambiguous intent to kill. It is a direct movement toward the commission of the crime after preparations are made. It is an immediate step that puts the plan in motion so that the plan would have been completed if some circumstance outside the plan had not interrupted the attempt. A person who attempts to commit murder is guilty of attempted murder even if, after taking a direct step toward the killing, he or she abandons further efforts to commit the crime, or his or her attempt fails or is interrupted by someone or something beyond his or her control. On the other hand, if a person freely and voluntarily abandons his or her plans before taking a direct step toward committing the murder, then that person is not guilty of attempted murder. If you find the defendant guilty of attempted murder under count 4, you must then decide whether the people have proved the additional allegation that the attempted murder was done willfully and with deliberation and premeditation. The defendant acted willfully if she intended to kill when she acted. The defendant deliberated if she carefully weighed the considerations for and against her choice and, knowing the consequences, decided to kill. The defendant acted with premeditation if she decided to kill before completing the acts of attempted murder. The attempted murder was done willfully and with premeditation and deliberation if either the defendant or Jonathan Hearn or both of them acted with that state of mind. The length of time the person spends considering whether to kill does not alone determine whether the attempted killing is deliberate and premeditated. The amount of time required for deliberation and premeditation may vary from person to person and according to the circumstances. A decision to kill made rashly, impulsively, or without careful consideration of the choice and its consequences is not deliberate or premeditated. On the other hand, a cold, calculated decision to kill can be reached quickly. The test is the extent of the reflection, not the length of time. The people have the burden of proving this allegation beyond a reasonable doubt. If the people have not met this burden, you must find this allegation has not been proven. The defendant is charged in count 5 with poisoning or adulterating food in violation of Penal Code Section 347A1. To prove that the defendant is guilty of this crime, the people must prove that 1. The defendant willfully mingled any poison or harmful substance with any food or drink. 2. The defendant knew or should have known that the poison would be taken by any human being to his or her injury. Poison is a substance applied externally to the body or introduced into the body that can kill by its own inherent quality. Arsenic trioxide is a poison. The defendant is charged in count 6 with being accessory to a felony in violation of Penal Code Section 32. To prove that the defendant is guilty of this crime, the people must prove that 1. Another person, whom I will call the perpetrator, committed a felony. 2. The defendant knew that the perpetrator had committed a felony or that the perpetrator had been charged with or convicted of a felony. 3. After the felony had been committed, the defendant either harbored, concealed, or aided the perpetrator. And 4. When the defendant acted, she intended that the perpetrator avoid or escape arrest, trial, conviction, or punishment. To decide whether the perpetrator committed the felonies of counts 1 through 5, please refer to the separate instructions that I will give you on those crimes. I was close. All right. We'll give closing argument now. The way it works is because Mr. Smith has the burden of proof, he gets the opportunity to go first. We'll then hear from Mr. Terry. But because Smith has the burden, he'll go last. So Smith, Terry, Smith, we only hear from Mr. Terry once, okay? Mr. Smith, whenever you're ready.
Just kind of general concepts initially. I just want to go over some of the sources of the evidence. What we have in this case is obviously a lot of witnesses took the stand, in excess of 30 witnesses in this case. As to judge their credibility, also part of the analysis of a witness is their corroboration to what they said. Corroboration can come through other witnesses. Corroboration can come through exhibits, things that have gone into the record, things that you have heard in the audio. There's photographs, documents, as I've said, and then also there is two types of evidence that have been provided in this case. I put in parentheses, both are equally good. Direct evidence, that's a witness up on the stand telling you what they saw, perceived, heard, and then circumstantial evidence. Those are pieces of evidence that can lead to a reasonable conclusion. In this case, you have received both types. The charges in this case, count 1, first-degree murder of Robert Limon. Count 2, the conspiracy to commit murder. Count 3, that Miss Limon solicited Jonathan Hearn to commit the murder of Robert Limon. Count 4, the attempted murder of Mr. Limon. Count 5, that's the mingling the arsenic trioxide with the pudding. And then count 6, that would be accessory after the fact. Just want to go over kind of there is different time frames for each of these counts. Count 1, first degree murder of Robert Limon, that's on or about August 17th. So that's the date that he was murdered. That's the time frame, that's the alleged in the information of the case. Conspiracy to commit murder, that's a broader time frame. That is on or about March 19, 2014, all the way until the date of arrest. Because a conspiracy does not end until you're contacted by law enforcement, because a conspiracy can include evading law enforcement. So as it relates to March 19th, there's a piece of evidence that's been testified to by Jonathan Hearn. That is the date he tried to acquire the arsenic trioxide. So that's the initial date. November 18, 2014, that's the date Jonathan Hearn and Sabrina Limon were arrested. Moving on to count 3, solicit to commit murder. This is from March 19th to the murder of Robert Limon. So as it relates to Miss Limon wanting Robert dead, March 19th, again, that's when Jonathan Hearn purchased the arsenic trioxide. August 17th, that's when Robert Limon was killed. Attempted murder. March 20th or March 19th, I think I wrote the wrong date, all the way through April 30th, 2014. Now again, these are on or about dates. It has to be around this time frame. Same thing for the poisoning or adulterating food from March to the end of April. And then last accessory, that's count 6. This is from when Robert was murdered to the date of arrest. So accessory is accessory after the fact. The perpetrator commits a crime, and then you help that person to evade law enforcement protection. Principles. In this case, Miss Limon is at times a perpetrator, At times, she is an aider and abetter. Both are equally liable, depending on how you see a charge, if you believe there's sufficient evidence. Directly committed the crime, perpetrator. So that would be Jonathan Hearn as it relates to the first-degree murder. Jonathan Hearn got on his motorcycle, drove to Tehachapi, shot Robert Limon, and then drove back. As it relates to first-degree murder, aider and abetter is the person that helps the perpetrator. So as to some of the charges, as I said, first-degree murder, Mr. Hearn would be the perpetrator. As to solicit to commit a crime, if you believe there's sufficient evidence, Sabrina Limon would be the perpetrator because she solicited somebody to commit a crime. So depending on the type of crime, the required action, Ms. Limon can either be a principal as a perpetrator or as an aider and abetter, but both are equally liable. To aid and abet, the perpetrator has to commit the crime, and then there has to be knowledge. So you have to know that the perpetrator is going to commit the crime. And it has to be knowledge prior to the crime. Before or during the commission of the crime, the defendant intended to aid and abet, so you have to have the specific intent to help that person. And then you did aid and abet. So you have to have knowledge of the crime that's going to occur. You have to have the intent to aid and abet, and you have to actually aid and abet. So what are the activities or actions that qualify as aiding and abetting? Well, it's a list of them. It could be one of them. It could be all of them. It could be three of them. It just depends. A person aids and abets if they know the unlawful purpose and specifically intends to and does in fact aid, facilitate, promote, encourage, or instigate the perpetrator's commission of the crime. I would argue in this case all are present, but it's up to you to decide what is present in this case as to the list. Again, it can be one, it can be all. First-degree murder, that is the unlawful killing of Robert Limon. There has to be express malice. There has to be the intent to kill. You have to also find that there is premeditation and deliberation. What premeditation and deliberation is listed below. It's also in the jury instructions. It has to be willful. You have to have intended for it to happen. You have to mentally weigh the pros and cons. You have to go through that decision process. Do I want this to happen? Do I want this act to take place? And after you've considered all of those things beforehand, you decided to kill, or you decided with someone else to have them go kill. That has to be present. When you get the jury instructions, it's kind of split into two parts as it relates to count one. The first one will be guilty or not guilty of first-degree murder. Behind that is what is the PC 189 allegation. So you have to find, if you're going to find first-degree murder, you have to find that there is premeditation and deliberation. If you don't find, you could start with, you find not guilty, you're done. If you think there is murder, you have to then find there is premeditation and deliberation. If you don't, then it's not first-degree murder, and then she would be guilty or not guilty. So those are the two findings that you have to make to have first-degree murder. Conspiracy to commit murder. There has to be an agreement, and then that agreement has to be that one of these individuals is going to go and kill. That's the nature of a conspiracy. A conspiracy is a criminal moment in time when a group of people, whether it be 2, whether it be 20, get together and decide, let's commit this crime. And it doesn't have to be that all of the individuals in the conspiracy go to commit the crime, as long as they agree that one of them will go and commit the crime. That's sufficient for a conspiracy. And then there has to be a completion of at least one of the overt acts. There is a list of 10. There has to be at least one of the overt acts completed by one of the members of the conspiracy. Solicitation, that's requesting, asking, or inviting another person to commit the crime. There has to be the intent that the crime be committed. That's the intent that a murder be committed in this case. You have to have either two witnesses or two options, testimony of one witness and corroboration. So you can have the testimony of Mr. Hearn, but there has to be corroboration of what he's testifying to. What is corroboration? That can be the defendant's acts, that can be the defendant's statements, that can be the exhibits, or the conduct tending to connect Ms. Limon to the crime. Attempted murder, a direct but ineffectual act done towards killing somebody. And there has to be the same intent as first-degree murder. You have to have the express malice to kill. And you have to have the same premeditation, deliberation. You thought about it beforehand, you weighed the pros and cons, and then you decided to act. So as it relates to murder, as it relates to attempted murder, you have to have a PC 189, which is premeditation and deliberation. Same thing as murder. The difference is in attempted murder, you can find there is no premeditation, deliberation, and still find the defendant guilty of attempted murder. Count 5, that's the poison in the food, and you have to know that taking that poison could cause the injury to the person. So again, an act is done, and you have to have knowledge of what that act can cause. And last, accessory. Again, this is from the date of murder, August 17, 2014, until the date of arrest. So you know the perpetrator committed a felony, and that perpetrator did commit a felony, and you assisted in some way, harbored, concealed, or aided, and you did that with the intent that they get away. That's an accessory after the fact. Just going to go through some of the evidence as it relates to the murder. Deputy Moncour, Senior Deputy Moncour, testified. He was dispatched on a suspicious circumstance. He arrived on scene. Sean Ware was in front of the shop. He was in panic, kind of a panic mode. The shop door was rolled up. He saw a male kind of leaned up or laying near a tire. He went inside, saw a pool of blood near that male. He called for assistance. Deputy Alvarez, she kind of responded at the same time as Deputy Moncour, also saw that white male, that's Sean Ware. Mr. Ware told her, basically he was crying. He's like, he has 2 kids. He was obviously quite shaken up by what he had seen inside the shop. She also observed Mr. Limon lying on the ground, and then she started setting up the perimeter so the crime scene could be put into place. Sean Ware testified. He had been a rapid responder for about 2 years. He had been the one that had the shift prior to Mr. Limon. They had talked for a little bit earlier that morning. And he was coming back to relieve Mr. Limon that night. He came about 6:45. When he arrived, he thought it was unusual that the garage door was down. He initially went into the garage, or into the shop, went on the right side of the truck, didn't see Mr. Limon, and then eventually came around the left, and that's when he saw him. He called 911. He attempted to resuscitate Mr. Limon. When he did that, when he pushed on his chest, he said blood came out of Robert's mouth. He went outside just to help the police so they would know where to go. He also testified there's no way to locate the BNSF shop unless you are directed to it. He even didn't know the address to the building. He had to look on a calendar when he called 911 that day to tell them where to go. And you're going to hear this quite a bit, but Sean Ware that day spoke with law enforcement and provided all of the information that he did to assist them. He actually never went back to go work there because of what he saw. Corey Hamilton, it was his shift being covered by Robert that day. Found out over the phone, went to the shop, talked to law enforcement, and provided all of the information that he knew to assist in the investigation of Robert's murder. John Justice, also a rapid responder. He was a reliever for the 4 that actually worked in Tehachapi, just like Robert. He would golf regularly with Robert. He's the one that called Mr. Limon that day, or the day prior, August 16th, and said, "Can you cover the shift?" He was tired. He had no arguments with Robert. I also asked him about the description of the John that you heard in the wiretaps. Mr. Justice is about 6'3", about 235. He has no motorcycles other than dirt bikes. Ryan Galindo worked in Tehachapi as a rapid responder. He testified that he saw the responder truck earlier in town that day. Again, he went to the shop, he spoke with law enforcement, and he provided them all the information he knew to help them in their investigation. Robert Garnis, he's a manager out of Bakersfield. He had worked with Robert Limon earlier that day on a train that had broken down to the west. Never had any issues with Robert. After he had heard, he went up to the shop, he spoke with law enforcement, and gave them all the information that he knew to assist them in the investigation. John Seaman, he was retired, got along well with Robert. Again, I brought him in based on the John description that was provided by Detective Meyer that you heard in the wiretaps. Some of the crime scene individuals that worked on it, Detective Adams, he kind of directed people what to do. Technical Investigator Thompson and Moore, they took photographs, they swabbed for DNA, they tried to find fingerprints, they seized items. As it relates to some of the things they saw in the shop, there was no footprints in any of that glass that came from the light in the ceiling. There was no footprints in front of the truck. The office was strewn. Items were everywhere. They seized cellular phones from Robert Limon. The wallet was still in his pocket. And they also found a projectile just below the light next to the truck. T.I. Moore, she fingerprinted following individuals for elimination prints. Corey Hamilton, his wife. Ashley Ware. Should have put Sean Ware in there as well. John Justice, Ryan Galindo, Aaron Galindo, and Dennis Stankovich. Those are the people that work there. Again, why did they do this? They're trying to eliminate suspects. And so they go and they assist by giving their fingerprints because they're trying to assist in the investigation. They did everything that was asked of them. Technical Investigator Thompson, he also downloaded the surveillance video from the area. You have a packet of photographs. This is from Patco. You also have some video that was from Goodrick Drive. There was a portion of video where you saw a male kind of walk around near a dumpster and kind of walk back towards the shop. That's at Goodrick Drive. And there's also a real brief snippet of the video from Selector, which is at East Tehachapi Boulevard. You can see a motorcycle driving by. There were searches on November 18th at the time of arrest, Lime Street. That's Jonathan Hearn's residence. They seized a motorcycle, firearms, ammo. They took contents of pockets from his laundry, a thrift store receipt. They did not search the chicken coop. Strawberry Lane, that's Ms. Limon's residence. At that location, they seized some cell phones and also some financial documents, which are evidence. And then at the arrest of Mr. Hearn, they seized his iPhone, cash, backpack, and the Glock firearm, which is the gun he actually used in this case. One thing I wanted to talk about before I went too much further is there's been a lot of phone records. And so listed, this is the phones. Mr. Hearn's phone was seized. It ends in 3569. Sabrina Limon's personal cell ends in 7844. The burner phone, 7958. The Limon's home phone, 8060. And then Robert Limon's cell phone is 7845. And just wanted to let you know that this is an extended time frame with all these phone calls. So that's why there is a lot of phone information contained on People's 18, People's 19. There's other records that are in defense exhibits. So I just wanted to kind of show you a quick tutorial on how to use them. So what I have up there is this is People's 19. And as you can see, it's probably a little bit small, but this is Mr. Hearn's cellular phone records. The first two are in an Excel spreadsheet. The first one is from April to June 2014. The second one is from June until September. And then the PDF files, or the files that you saw yesterday that the defense used, that's from November to about the April time frame. So as it relates to, I'll just go to the first one, April to June. And you will have a computer in the back, so you'll be able to do this as well. You just go to the top part, line 3, go through, and you simply filter. And then you can go and either select by phone number, select by date. One of the things I did during the trial is that I selected based on Ms. Limon's home phone. And then what that does is it gives you all of the Limon's home phone connections and calls to Jonathan Hearn's phone. You know this is Jonathan Hearn's phone record, so whatever phone he's connected to, that's who he's speaking to. So the records tell you whether it's outgoing, so in this case this would be from Mr. Hearn's phone to this other phone, or it says incoming from that phone to Mr. Hearn's phone. So as it relates to the home phone of the Limons, here you can see all the connections and calls in April from Sabrina Limon's home phone to Jonathan Hearn's phone. April 6th, April 7th, April 8th, April 9th, April 10th, April 12th, 13th, 14th, 15th, 16th, 17th, and so on into the 24th. And then as you can see, on April 25th, that's when there are no more calls between April and June from the Limon's home phone to Jonathan Hearn's phone. So that's how you can use the phone records. There is thousands of phone records. There is thousands of text messages listed, not only relating to Ms. Limon's phones, but also other people that Mr. Hearn's contacted as well. But that's how you can go through and select what you're looking for in the back. Dr. Whitmore, he was a pathologist in this case. He called it gunshot 1, gunshot 2. He didn't know what order they came in. But gunshot 1 went in under the left chin, front to back, grazed left side of the spine, exited the neck, and, as with both gunshots, was shot from close range. Gunshot 2, entry, exit, then re-enters, shot upward, right to left. Some of the things he noted, there was gray black residue in the gunshot wounds, causing tattooing or stippling. Said this is likely from the gunpowder. He also observed a close range imprint, and it could have been left by a round suppressor or a barrel of a gun. His opinion was the cause of death, multiple gunshot wounds, and the manner of death, homicide. You also have in the exhibits the death certificate of Robert Limon. Jason Bernatine. This is kind of where the investigation began as it relates to Jonathan Hearn and what led ultimately to the arrest of Mr. Hearn and Mr. Limon. He received letters, text messages, voicemails from Jonathan Hearn, and he thought it was weird. He thought it was odd. He had worked with Jonathan Hearn in the years prior, and based on that contact and what he knew about Mr. Hearn's relationship with Sabrina Limon, he called law enforcement because he knew that he was a likely suspect. He had been present previously when Robert spoke with Jonathan. He met with Detective Meyer, and he gave him the information he had to assist in the investigation of Robert Limon's murder. He also later ran into Sabrina at a store nearby. Robbie brought up Jonathan Hearn. He said that Sabrina hushed Robbie and changed the subject quickly. Moving on to Kelly Bernatine. She also contacted law enforcement. She had seen Jonathan nearing Hellendale on a couple of occasions. She saw Jonathan's vehicle. She thought it was suspicious. She provided the license plate information to Detective Meyer. And again, she did that because she knew he was a likely suspect, and she was providing all the information she could to assist in the investigation of the murder of Robert Limon. Moving to January this year, some of the follow-up investigation. Detective Miller located bags in the chicken coop, one to the rear, one to the back right. There was a layer of dust over it. He seized those items. There was also a Walmart ammo receipt contained in a book. Technical investigator Thompson took photographs of the items from that day. He took photos of the silencer that had been found in the chicken coop, photos of the freeze plugs within that mag light to deaden the sound. He also noted the silencer had a threaded end, and he took photos of all the materials, kind of shop manuals that were found in the backpack. Technical investigator Moore, she did a Cellbrite download of Jonathan Hearn's phone that had been booked into evidence in November of 2014. She was given a passcode that had been received from Jonathan Hearn in January. She put that into the computer, downloaded the information, and a lot of that information, the bulk of it, is what you see in these extraction reports that have been marked into evidence. Detective Garcia, he was present during the search on January 3rd. He's the one that assisted in finding arsenic in the paint buckets that were outside the garage. In that paint bucket, we located ethylene glycol, copper sulfate, also arsenic trioxide. The bottle was half empty. There was also hydrochloric acid, test tubes, and a scale within that same bucket. Talk about Jonathan Hearn's testimony. He testified as to when the plan began. It was around the early parts of 2014. It started out as joking. He said it turned dark and eroded. They kind of shared some ideas of how to get rid of Robert. They talked through some ideas. Sabrina expressed that it would be simpler if Rob was gone. That divorce was not an appealing option to her because of what comes with divorce. The kids, having to share time, those issues. They plot together to kill Robert so they could be married, and they planned the killing of Robert. Jonathan Hearn testified that Sabrina persuaded him that she needed her husband dead, and she approached him emotionally. I'm sure you saw that emotion kind of on stage here as it relates to some of the things that Ms. Limon testified to. But that's how Jonathan Hearn was approached by Ms. Limon. Sabrina said that life at home was becoming insufferable. She spoke to Jonathan kind of about the emotional things that she was going through, the difficulties she was having, and they began to plan their future together. Their home, their marriage, how to raise the kids. And there is plenty of information in Ms. Limon's own hand about this planning for the future. They decided on poisoning Robert at work in Tehachapi. Why poison? Why Tehachapi? Well, he worked alone in Tehachapi. There was a smaller hospital there. They kind of thought about the level of care perhaps would be less. It would also be less suspicious due to distance, about 2 hours away where he worked in Tehachapi from his home. And also a prior medical condition, if he had symptoms from the poisoning. We thought due to the prior medical issue, then they'd be less suspicious. The arsenic trioxide attempt, time frame following Valentine's Day. Jonathan Hearn purchased arsenic online. This is People's Exhibit 65. You see a receipt from Art Chemicals for arsenic trioxide, 100 grams. This was taken off of Jonathan Hearn's cell phone this year. He purchased that with a PayPal account, and he had it sent to his grandparents' art studio. Towards the end of April, he mixed a batch, placed it into Tupperware, took the family-sized batch along with the smaller batch for Robert, gave it to Sabrina at her residence in Hellendale. He was informed by Sabrina that she had placed the poison into Robert's lunch. Some of the Google searches done by Jonathan Hearn in preparation for the delivering of arsenic in the pudding to Robert. April 15th, 2014, he searched for arsenic homicide. Again, April 15th, was on CNN looking up arsenic murder. March 30th, 2014, search for mixing arsenic trioxide. March 8th, easy banana pudding with vanilla wafers. April 15th, visited Hearn Sheriff Hearn. Why is that important? Tehachapi's in Hearn, and the coroner would be the one checking out whether or not Mr. Lomond had been killed in a homicide. And lastly, Wiki answers. How soon after a person dies does a life insurance policy pay out? That is at the end of March when that search was completed. Arsenic attempt. This is the arsenic, half full bottle, that was found this year in a bucket at Jonathan Hearn's residence. Also of note, one of the notes that we were able to pull off his phone this year. It's been labeled as People's Exhibit 70. This is in your iPhone, you have a place marked notes. You have the date, modified, and you can see buy Tupperware, milk, and med pestle. Make sample batch, mix with water, neighbor dog. Those are all the things that Mr. Hearn testified to that he did in preparation, along with Sabrina Limon, to deliver the arsenic trioxide via the pudding to Robert Limon. Also of note is at the bottom, we talk about planning. The planning, what was going to happen. Talked about the future, not just in Ms. Limon's notes. They were planning on being together. They were made for each other. In Mr. Hearn's notes, all the way back from April 23rd, 2014, initially created in March 3rd, he's got savings, ring, $5,000. Wedding, $10,000 at the beach. Honeymoon, $10,000. Again, this goes to show the planning they were going to. They were going to get rid of Robert Limon. They were going to get married as well. That was the plan in this case. You had testimony by Mr. Roten as it relates to April 24th. Jonathan Hearn didn't remember the exact date of when he delivered the poison to Sabrina. He said that it was on a time frame when Robert worked in Tehachapi for 2 days in a row. As it relates to, this is People's Exhibit 23. As it relates to Robert Limon, this is April. The 24th and the 25th. It shows that Robert Limon was supposed to work for Sean Ware in Tehachapi on 2 consecutive days at the end of April 2014. This shows Jonathan Hearn's cellular phone was in the area of Hellendale on April 24th, 2014. Just wanted to make note of this, that Sabrina Limon did speak with her husband on April 25th, 2014. There was a question posed that she had not. She did call her husband after speaking with Jonathan Hearn on that date, April 25th, 2014. The upper portion, that is Jonathan Hearn's cellular phone. He is calling 241-8060. That's Ms. Limon's phone. They speak for about 70 minutes. Later on that same morning and early afternoon, Ms. Limon calls from her phone to her husband's phone, who was in Tehachapi. You have those records in the back. There is cellular phone records that show Robert was in Tehachapi that day as well. So she called Robert after speaking with Jonathan that morning. Just as a note, one of the contentions of Ms. Limon is that the only reason that they got this burner phone was because they didn't want her husband to know. Well, you'll see in the records the last cellular phone call made by Ms. Limon was in early March. Throughout the whole time of April, all the way up until April 25th, the day that the pudding was placed into Mr. Limon's lunch, they spoke extensively between her home phone and Mr. Hearn's phone. There was between April 6th and April 25th, 2014, and that is when the burner phone began to be used. There was 1,278 minutes of calls between Jonathan Hearn and Sabrina Limon's home phone. That is 21 hours of talk time in 23 days. So as it relates to the contention that, we just got it so my husband wouldn't know, there wasn't any issue going on with her husband not knowing because she used her home phone constantly. But on the day that they tried to kill her husband with poison, and they decided that law enforcement could learn of their connection with each other, that is the day these calls stopped. And that was to escape law enforcement detection down the road. After the arsenic attempt, they agreed to wait about 3 to 4 months. They decided to do that because the cell phone records would connect them to each other. Jonathan Hearn said this was the period of darkest conversations about Robert. Sabrina would keep him updated when Robert was going to work. They also continued to work on a plan for their next attempt. The plan was to confront Robert directly in Tehachapi. The plan was for Jonathan to directly confront him in Tehachapi. How did Sabrina assist? She described the BNSF facility. She offered to find pictures, informed him what to expect inside the shop. She told him about the forward-facing cameras inside the trucks that had been recently installed. That's why there was no footprints through the glass to the front of the truck. Recommended that he take his motorcycle versus his big truck due to the noise. And also towards the late summer, she wanted him to kind of hurry it up. There was an upcoming trip, and she didn't want to go on. May 23rd, there was photos taken of the facility at Goodrick Road by Jonathan Hearn. This is People's Exhibit 71. There is larger photos in the back. As you can see, they're labeled. Image 0690, image 0691. And what that does is that relates to the list of images to the front, 0690. There's also a capture time. What a capture time is, whenever you take a picture in your phone, it says what time you took the photo and which phone took the picture. So here, iPhone 5C, that's in evidence. Capture time, May 23rd, 2014 at 7:08. And there's also photos taken at 7:09. Well, Mr. Hearn testified that he contacted Sabrina Limon immediately after he found the BNSF facility. As it relates to the phone records, he took photos in 1908, 1909. These are from the burner phone's records. The calling number ending in 3569 called the burner phone at 1910 or 7:10. So 1 minute after he took the photos, he called Sabrina. That only lasted 29 seconds, so a connection was not made. The next occurred at 1911. A text message originated from 3569, that's Jonathan Hearn's phone, and arrived at Sabrina Limon's phone. And then at 7:35, a call lasting 23 minutes started with Sabrina Limon's phone and went to Jonathan Hearn's phone. All of this corroborates exactly what Jonathan Hearn testified to. Now, Jonathan Hearn, while he's sitting in custody, does not have access to these phone records. But the phone records lay out exactly what he testified to. This is the PowerPoint slide from Mr. Roten. This shows at 7:35, the call was made from the area of Tehachapi and then ultimately traveled towards the east. Towards the east is Hellendale, Hesperia area, where they are from. There's also testimony about the amount of phone contact between Sabrina Limon and Jonathan Hearn. Deputy Mountjoy testified to over 5,900 contacts in the records that he had. You'll have those People's Exhibits 18 and 19. And then also Joseph Gates. There was a packet. It's been marked as People's 21. What he did is just analyze the month of August.
Just a minute. I need to give the recorder a break. Let's take our morning recess. Everybody back at 11 o'clock. Remember not to form or express any opinion or discuss the case. See you back at 11.
Remain seated. Come to order. Department 6 is in session.
All right, we'll go back on the record on People versus Limon. She's present in court, Mr. Terry. People are represented by Mr. Smith. We do have all 12 plus 4 in the box, Mr. Smith, if you'd like to continue, sir.
Moving on to August 17th, the date of Robert Limon's murder. What I have up on the slide is the phone contact between Sabrina Limon and Jonathan Hearn. There was a total of 224 minutes of phone conversation that day. There was 214 minutes of phone conversation prior to Jonathan Hearn leaving to kill Robert Limon. One of the things I wanted to point out is there is a call made at 8:47. That call lasts till 9:33. You will have the Walmart receipt in the back. The receipt is for the purchase of the ammunition done by Jonathan Hearn. That's People's Exhibit 33. Jonathan Hearn was on the cell phone with Sabrina Limon at the time that he was buying the ammunition that he used to kill her husband. It's just like Tehachapi. He's up in Tehachapi, scouting the location, calls her on the phone. Here he is. He's buying the ammunition. She's on the phone. Everything they do, they might not be present together, but they're present on the phone and they're present in their intent and what they're trying to do. As to those 3 hours and 45 minutes of conversation, Sabrina asked Jonathan how he was feeling. Said Robert would put up a fight, told him to be careful. She asked him about what precautions he had taken, and he told her about the reflective tape on the bike, the clothing, etc. She was worried about the time that he was starting because Robert's relief might show up at the time that Jonathan was up there in Tehachapi. They again discussed how to make it look like a robbery, and they also discussed the false narrative to provide to law enforcement when law enforcement contacted Sabrina following what was going to happen to her husband. Jonathan Hearn arrived in Tehachapi August 17th. He parked near an asphalt pile just on the north side of Goodrick Road. He got off his bike. He went into the area of Goodrick Road. He eventually walked across the middle of the complex. You saw him on surveillance video doing that. He didn't go in immediately into the shop. Ultimately, he stood outside the shop. He prayed about what he was about to do, but he felt that the murder was inevitable based upon the purpose of the plan that Sabrina and him had for the future. He entered into the shop, contacted Rob near the fridge. He began pulling the gun from the backpack with the silencer on it. He fired the gun while it was in the backpack. He did not see where the first shot hit Robert. After he shot him, he walked around the back of the truck, went over to the shop, took everything, kind of threw stuff, put some stuff in his backpack. He returned to Robert's location by the truck and fired another round into Robert. He made the garage door go down. He ran out of the shop door, and he testified that he actually felt relief after he killed Robert. He drove towards home. One of the first exits near Tehachapi, he changed out of his disguise, put those items in his backpack, put the license plate back on, took off the reflective tape, and proceeded back towards his home in Hesperia. He got to the Pilot gas station, which is at 58-395, or the Four Corners area, and he had to gas up there. That video is in evidence for you to review. When he returned home, he immediately texted Sabrina. Then he talked to her. He told her basically that he had done it and that things would be changing. He told Sabrina that he was going to get rid of some items. She was surprised that he hadn't already done that. Moving on to Ms. Limon and her contact with law enforcement. Realize at this time when she's speaking with Detective Meyer, she knows some things that only two people know. She has told what would be the primary suspect in a law enforcement investigation killing of a husband, that she told that person where her husband worked. And she had told that person that her husband would be working there that day, and she knew that they had had issues before. But when she spoke with Detective Meyer right after the murder on August 18th, early morning hours, did Robert ever have any trouble with anybody? She said never. Any issues with the relationship? No. Nobody you could think of that might be upset with him? No. Problems with coworkers? No. But she did, in her first 2 interviews, talk about what she had done that day. I talked to Robert on the phone. I had the kids were, one kid was away, one kid was at home. We went to my mom's house. We went to church. What she talked to Robert about. So she gave all this information about what she had done that day. But she failed to mention that she had talked with Jonathan Hearn. And the calls that she had with her husband, the call she talked about at 1 o'clock, she was actually on the phone with Jonathan Hearn. As you can see, there is a voice call from 7958, that's the burner phone, to 3569, that's the top portion. That's an 80-minute phone call, that ends at 1:35. And then at the bottom, you can see ending in 7845, there is a call to the home phone, and there is a 1.5-minute call between Robert's phone to Sabrina's cell phone. That is the last contact she had with him. Everything else after that is a voicemail, according to his phone records. Her last contact with Robert, her husband, was while she had the man who killed her husband on the other phone. She also failed to mention, because she said, I tried to call him over and over and over again. She failed to mention, while she was doing that, she had the man who killed her husband on the phone. The records show the first 2 text messages. These are Jonathan Hearn's records. When he got home, he said he immediately texted her. That's at 7:50:03, 7:50 and 16 seconds. Then at 7:50:33, that's an incoming phone call from Sabrina's phone, 7958. These are the records of Robert's cell phone that he had on. As you can see, between 1951 and 201 or 801, there is 1, 2, 3, 4, 5, 6, 7, 8 phone calls. So this whole thing about, I was frantically calling my husband, that's a false narrative. So what does she have? She has a phone that she doesn't think anybody knows about, that law enforcement wouldn't know about, and then she's calling on the phone that they can get, and that's what she tells the cops about. Why would she do that? There's only one reason to do that. Because if law enforcement ever looks into the phone records, she thinks all they're going to find is, I called my husband over and over again. But she was calling her husband over and over again. But she failed to mention to Detective Meyer, she did that while talking to the man who killed her husband. August 18th, this is hours after she talked to Detective Meyer. And she told Detective Meyer later that, maybe it was Rutledge, that she had texted Jonathan after, but there was 12 text messages from Sabrina Limon to Jonathan Hearn. I didn't put the outgoing from Jonathan Hearn because there were some. These are just text messages from Sabrina's phone to Jonathan. Her husband hadn't even been dead a day yet. And that's how many text messages she's sending to Jonathan Hearn. Interview, August 22nd. Again, Detective Meyer. Did Robert have a girlfriend? No. Have you ever had a boyfriend or anything like that? No. Again, she's lying to law enforcement. She's giving the false narrative that they had agreed upon, her and Jonathan Hearn. Detective Meyer even tells her, we're trying to eliminate all possible suspects. He's not just, I'm just asking this because I want to know about your sex life. He's asking because he wants to eliminate every possibility. That's what she knows, because that is what is being said to her by law enforcement. What happens after that is Robert's August death turns into Sabrina's September love. And you'll have in the back some of the text messages. I put just a few, a sample. September 5th, 2014, 19 days after her husband's death, 19 days. I adore you, Jonathan Hearn, you sexy guy. 21 days. Ah, my poor guy, I love you so much, baby. I miss you so much tonight. I miss you and feel God's purpose and strength working in my life in our relationship. 21 days after her husband had been brutally murdered. She's in a relationship with the man who killed her husband. All caps, I love you, Jonathan. I want to kiss you right now and not stop. This isn't just some kind of emotional thing. This is her sexy guy. This is the guy she wants to kiss. 21 days after her husband had been killed. She even told Jonathan Hearn's sister, Emily, the best is yet to come. Her husband had just been killed. Why was the best yet to come? Because this was the plan. This was anticipated. How do you move from the death of your husband, you're raising 2 kids, to immediately adoring a young, sexy guy? Because it's the plan. With Daniel Flatten from BNSF testified he had contact with Miss Limon. Afterwards, he talked about the railroad benefits. They kind of have their own Social Security. That's the finances on death that go to her, and then also to the children. Talked about their life insurance policy. He also talked about a possible settlement for someone injured at work for BNSF is from the hundreds of thousands into the millions. That's how much you can get. He delivered the benefit package to Sabrina Limon. He said it was too early to discuss a settlement. He said the investigation was ongoing. She said that she did not want any attorneys involved. This relates to the motive. Why would you have your husband killed? Well, if you get a divorce, think about where she's working. She's a part-time employee at Costco. If she gets a divorce, all she gets is half of the money, a little bit more than that, from her husband. What does she end up in this circumstance? $330,000 in life insurance. Oh, she got that. You have the records in there. She got the lifetime railroad benefits for her. She got the money for the kids until the age of 19. She had a possible settlement into the millions of dollars. She had a higher wage earning new husband, firefighter, on his way up, going to arson investigation school. They also talked about building a new home in the excess of 2,000 square feet, overlooking an area. She also had a lifestyle motive. She wanted to leave her life behind. She wanted a new life. That's what she set up with Jonathan Hearn. With killing somebody and planning to kill somebody comes paranoia. And you heard some of this through the wiretaps. This is a text message from Jonathan Hearn. He was feeling apprehensive. They were worried about cars they saw out on the street. They were worried about a red Titan. You heard things like that. Jonathan Hearn would arrive late at night after the kids were in bed. Again, this is evidence to show that this was a plan. Do the murder, hide from law enforcement, not tell anybody, and then eventually set up their new family. Wiretaps, I know there was a lot, but the reason that they were played is it shows the depth of their relationship. Again, Robert had barely been dead just over 2 months, and you heard over and over again how much they love each other. You're able to hear the access Sabrina gave to Jonathan Hearn to help raising her children. You're able to hear that in the wiretaps. You're also able to hear their descent kind of into paranoia. They're seeing things that aren't even there. Now, why do you do that? Because you plan to kill somebody and you know law enforcement is going to look into you. You're able to listen to their active law enforcement countermeasures. Jonathan Hearn using a voice-over internet phone. You heard that Sabrina almost had a heart attack when she saw a 661 phone number come up on her phone. What's 661? That's where Detective Meyer works, Kern County. You also heard her call the station phone after Detective Meyer had given her the identification or ID of a suspect, white, male, skinny. So what does she do? She doesn't call Jonathan Hearn's cell phone that she's called constantly. She calls a station phone in hopes that law enforcement's not listening. And then also, just for good measure, I wrote it a couple times. Sabrina's lies, 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 because that's all you heard.
I just got a text message from Detective Meyer and asked me to call him. So I'm going to.
Okay.
And
I'll pray.
okay. Okay, I just wanted you to pray. And pray and call him.
God, please help us. God, please help us to be wise. Help Sabrina to have the right words. Please help everyone to be. God, please help us to live for you.
This is from November 9th, after a call or a text message from Detective Meyer. These wiretaps are being back. November 9th. Listen to the first 3 wiretaps. Later on in the CRF interview, Miss Limon was asked about this exact wiretap. Detective Rutledge says, does an innocent man and woman, for that matter, act that way? Her response was no. Why did she say no? Because an innocent man or woman does not act that way. It's common sense. Also, this conversation on November 9th at 10 in the morning, is it safe to say that when you made this phone call, you knew Jonathan had murdered your husband? Her answer was yes. Based on her own words, when she was talking to Jonathan in that call, and ultimately Detective Meyer, she knew her husband had been killed by Jonathan Hearn.
So there's no information at all.
Honestly, I don't have anything, and I wish I did, but I think we're kind of getting into a dead end, and I was hoping that by re-releasing that news video, that will spark something with somebody, and they may have seen something, and they'll give me some secret witness tips, or they'll either call me or something like that.
So Detective Meyer has just told her, we got nothing. The death of her husband, we're investigating. Robert Limon, we have nothing. So what's her response? She immediately calls Jonathan Hearn.
I'm sorry, I'm going to walk out to church right now. Everything's fine. I'll talk to you after church when I see you. Is that okay?
Yeah. Everything's fine.
Yeah, everything's fine. You just said that, they don't have anything, and that they're re-releasing the same video because the other one won't be back for like 2 months.
Everything's fine because they haven't found him out. But everything is not fine. If you're an appropriately acting widow, everything is not fine. If they're at a dead end, you have a completely different response. Why is everything fine? Because Jonathan Hearn and Sabrina Limon didn't think law enforcement knew what they were doing at this point. That is the reason for her response. She did not want the murder of her husband solved. You can tell from these calls. Now, the entire calls are back there. You can listen to the whole context. I only used excerpts because there was quite a bit of time, and I didn't want to play the whole thing. November 13, 2014, another Detective Meyer interview. Same relationship questions, same lies from Sabrina Limon. November 14th, I asked about this on the stand. I asked her if she was concerned about a BNSF private investigation. She said she wasn't. So at that point, I figured I'd play a wiretap that I hadn't played yet. Jonathan Hearn says to her the other elements of everything that's going on, there was going to be a private investigation too. She responded in the affirmative. And then she says, I feel like I could be being watched. So she's concerned not only about law enforcement investigation, she's concerned about a private investigation. Why is she concerned about a private investigation? That's where the possible millions of dollars would come. If they don't find out about her and Jonathan, she gets the money. Moving on to November 17th, Detective Meyer gives her a call. That call is in evidence. He gives a suspect description. This isn't just a random description of a guy he happened to see on the street. This would be the suspect description. White, male, skinny, leaving around the time of the murder. So he's giving her information of what this person is. This is a guy on video I see leaving around the time of the murder. Pretty self-explanatory. Subject named John, or like a John, possibly knew Rob, motorcycle, had a beef with Rob. So these calls with Detective Meyer, 1834 hours, 1921, 1923. So what does she give him? Oh, there's a John Justice. There's a John Simon. Well, you saw those two individuals. They don't match the description at all. They don't have motorcycles that match. Detective Meyer talks about a chopper. Neither of them have those motorcycles. So what does she do after that? There's a 7-minute phone call at 1923, so about 2 minutes after she gets off the phone, she calls Jonathan Hearn on the station phone because she thought law enforcement couldn't listen. He could barely hear Jonathan Hearn through any of those station phone calls. He had a cell phone with him. 1932 hours. That's when she calls and says, hey, give me a call on this line. He then calls her back. And again, this is the murder suspect. That's been made perfectly clear by Detective Meyer. Again, white, male, skinny, leaving around the time of the murder. Named John, possibly knew Rob with a motorcycle and a beef. So, who does she call? Jonathan Hearn. And what about Jonathan Hearn? Oh, 100% match for the description of the suspect. 100% match. She testified that she was confused and didn't know who Detective Meyer was talking about. Well, then why in the call was she asking about his motorcycle? Of course she knew he was talking about. She's asking him specifics about a motorcycle.
I guess so. He said it's on the corner of 58 and 395, I think. I'll reach the text. Because I didn't see that, but then she just called me. And she's also, I don't know, she says, hey Sabrina, I just found out. Hey Sabrina, I just found out that the video from a private gas station at 58 and 395 are heading out there, and it looks like the suspect made a fill up.
And then the next close-up is at the end of the excerpt.
Okay.
What's that?
I don't know if you listen.
I don't know what's going on. What's that?
I said, that's strange, but I wonder why he played television with this stuff, you know?
Yeah. That looks like they're all going to show up here.
Just to break down the content of that excerpt, it looks like the suspect may have filled up. So what are we talking about? We're talking about the person that killed her husband. And then at the end, even though Detective Meyer tells her that he's heading out there to get the video, she thinks they're going to show up here. Why does she think that? It's called consciousness of guilt. She knows that she's committed this crime along with Jonathan Hearn, and she thinks Detective Meyer's on his way to arrest her. Moving on to November 18th, these are the text messages from Detective Meyer to Sabrina Limon. Good morning, Sabrina. Sorry I was up late last night. I took this video from the video I recovered last night. Basically, does this person look familiar to you? This is our suspect. Again, suspect, the person that killed her husband.
Hello?
Hey, is everything okay?
Yeah, I'm sorry for bothering you.
Oh, no. Hey, you've never been so today, so you are not a bother.
It's going to talk to you again. I was just watching that video.
Mm-hmm.
They were going to take a video of you.
What's that?
I said, do you think that's just, I'm tripping. I have such a bad headache, too.
She knew the video was Jonathan Hearn. says it in that call. Later on, she says she didn't know who it was. She knew exactly who it was. She's tripping. She's tripping. Because she knows they're coming. You heard the call about a court case impending. She knew they were coming. You heard the call before. I feel like they're coming out here. That's why she's tripping. She knows it's coming to an end. She's even got a bad headache over it. Let's talk about the day of arrest, the interview with the Detective Rutledge and Detective Trevino. The next slides are before they start telling her the evidence they have. So if you listen to it, you can hear them. I think Detective Trevino says something about we're not Mickey Mousing around here, and he's got a big binder of stuff. So all of this comes before she starts to realize how in-depth the investigation is. She starts out, well, there is a Jonathan, and I had a relationship with him. That's a past tense thing. What's that? That's a lie. Again, about Jonathan Hearn, it was on and off thing. As far as that goes, Detective Myers sent me a video. I don't recognize who's in the video. That's a lie. So where the John comes from, I don't know. It's a lie. Did Rob ever know about this relationship? He did, and then that's when we called it off, That's a lie. So obviously you're not talking to Jonathan anymore. No, he's been around now since he found out this happened. Well, that's a lie. He'd been around constantly. And this one I think is particularly interesting. I'm curious. So you said you cut it off. That's Jonathan Hearn. Do you remember what time of year you guys cut it off? The relationship, talking to him. And what does she say? Maybe April. Well, why is that interesting? Well, that's when they had made the prior attempt and they agreed to get a burner phone to escape law enforcement detection. So what is she doing? To law enforcement, she's using their plan to escape their detection as it relates to their phone. Maybe April. That corroborates exactly what Jonathan Hearn testified to as to why they got the phones. She stuck with the plan. Ultimately, Detective Rutledge, Detective Trevino informed her about the phone records, and then you heard the rest of the interviews. She started to give a little bit more information. She happened to mention that, I told Jonathan Hearn where Rob worked. I happened to mention that Rob was working at Tehachapi that day. And eventually she told them on November 20th that she knew Jonathan Hearn had killed her husband. So as to the pre-murder relationship plan, before the murder, it's written, it's testified to, and it's in their interviews. They discussed the future together, including a home. They discussed raising the kids together. A discussion of, in her words, like if anything happened to Rob. Discussion of church and leading godly lives, how badly things were being done. Now, these last two quotes were in an interview with Detective Meyer. This is the actual words. November 18th. We talk about things, being together. The kids. Talk about the kids. Raising the kids. We talked about it a lot, how badly things were being done. They talked about raising Robert's kids before Robert was dead. Detective Meyer, he's kind of find out how long before the murder they were talking about these things. Miss Limon, we talked about living for God, maybe like a month, 2 or 3 before. That was the reason for the plan. She didn't like her life. She wanted to move on to the new life. She wanted to raise the kids with Jonathan Hearn. That's her own words. That's what she said. That's not Jonathan Hearn up on the stand testifying as to that. That's what Miss Limon said in her interview. You'll have in the back, you'll have her Valentine's Day card to Jonathan, where it talks about, I love you for hopes and faith in our future together. I love you for so many reasons. I've only written a few. I was made for you. That was the plan. Here's the other card. This one is People's Exhibit 62. Unlimited, how you make me feel. Unforgettable, every moment with you. Unlimited, the possibilities for our life together. That's what happened in this case. Everything that she wrote, everything that she talked about is exactly what happened. To love each other, what a priceless gift. I cherish you, our love, and the blessings God has given us. The blessing was they were going to be together. That's the blessing. Written is what they were going to do, the future. You heard her talking about her home. She even bought some items for the home about 3 weeks after Robert had died. So that was their plan. And they 100% fulfilled that plan. You have it in her own words. They were together in a relationship, that they had started a new life, that she was purchasing items for their home 3 weeks after his death. You heard it in the wiretaps. You heard it, you can see it in some of the text messaging. We're raising Robbie and Leanna together. They were leading godly lives. And as Sabrina said, she was ready for us. She was ready for us. In this case, you heard a lot of people testify about Robert. Everybody loved Robert. You heard it from countless people. At least 10, 12 people. But 2 people saw him as an impediment, as something in the way of a future. And one of those persons testified because he shot and killed him. The other one is the one who put it in motion, and she sits here in the courtroom today. Everybody gave everything that they knew to help in this case. The BNSF guys, the Bernatines, they gave all the information they knew. There was only 2 people that didn't give any information. The person who killed Robert Limon and the person who sits in court today who helped plan it. Why did they do that? Why did they not give any help? Why did they not give any information? Because they were trying to get away with it. The charges that have been filed against Miss Limon are to hold her accountable for what she did, for what she set into motion with Jonathan Hearn. That is why she's charged with conspiracy to commit murder. She was part of an agreement to get rid of her husband so she can do what they did, which is move on to a new life. And I ask you that you hold her accountable to those charges. Thank you.
All right, thank you, Mr. Smith. Mr. Chairman, whenever you're ready, sir.
Thank you. Good morning, ladies and gentlemen.
Good morning.
A long road. Takes a lot out of you. And done a lot of these. And so at this point, what I'm going to suggest with me, breathe in, breathe out. Ladies and gentlemen, you had to listen to a lot of testimony in this case. You had to listen to a lot of recordings and evidence that's been submitted to you. You have to, as jurors in this case, in judging the facts of this case, look at all the evidence. And as the judge has instructed you, the arguments by Mr. Smith, myself, that's not evidence. What Mr. Smith has highlighted to you is the things that he believes support his theory of the case. That's his job. That's what he does. My job is to defend Ms. Limon against the allegations that they've made against her in this case, and to point out the evidence with regards to this case that we believe shows that there is a basis for reasonable doubt. Because That is ultimately what you must decide. They have to prove to you beyond all reasonable doubt each and every part of each and every crime. It's your job to sift through this evidence, and I mean all of it, in reaching that determination to determine whether or not they have met their burden of proof. If they have not proven to you beyond all reasonable doubt that Ms. Limon committed these crimes, your duty is to acquit. That is your obligation as jurors. You are the judges of the facts of the case. Your job is not to come in here and make moral judgments about Sabrina Limon and her relationship with Jonathan Hearn or her relationship with her own husband. You are the judges of the facts. You've basically had the opportunity to see Sabrina's life played out in this little soap opera, if you will. You've heard about her flaws. You've heard about the mistakes she's made in her life. And ultimately, hopefully, you've got somewhat of a picture of what a type of person she is. You've heard it from all the different witnesses. She's an outgoing, happy, thoughtful, caring person. And it's your determination as to whether or not the people have met their burden. The issues in this case are relatively simple in a lot of ways. The first issue is did Sabrina Limon solicit and conspire with Jonathan Hearn to kill her husband? Either by the means that he claims of poisoning her husband, or ultimately in the means by which Jonathan Hearn murdered her husband in cold blood. Ultimately, the other issue you have to address is whether Sabrina Limon knew that Jonathan Hearn killed her husband, and whether or not she failed to report that to the police. Those are basically really what it comes down to, the two primary issues you have to reach. The evidence in this case is twofold. You have circumstantial evidence and the direct testimony and direct evidence of the alleged conspiracy and solicitation by Jonathan Hearn. We'll talk about the circumstantial evidence first in this case. Sabrina not telling the police about her and her husband's open relationship and her affair with Jonathan Hearn. The cell phone records that Mr. Smith and I both have submitted in this case, and also the cell phone downloads. And you heard testimony with regards to those. Those are where they actually plug the phone into a machine that then takes the data and information off the phone and downloads it into another format that you can then review. Her notes, cards, gifts, and her professions of love of Jonathan Hearn. The telephone intercepts of the conversations that the police and Mr. Smith has played extensively during the course of this trial. Telephone intercepts and conversations that she also had with BNSF personnel, such as Sean Ware, or Corey Hamilton that occurred after Jonathan had killed her husband. You've got the circumstantial evidence regarding Jonathan Hearn's research about arsenic poisoning, life insurance payouts, and research regarding recipes for banana pudding that he did. And then you've got receipt of life insurance payouts after Robert's death, and inquiries about settlement with BNSF. The direct evidence of the alleged conspiracy is in the testimony of Jonathan Hearn. Now let's talk about the circumstantial evidence first. Sabrina's failure to tell the police about her and Rob's open marriage. That leads also to the fact that she got involved in a relationship with Jonathan Hearn, an affair. Now, the prosecution's view is she was hiding her affair with Jonathan Hearn because she had conspired with him to kill her husband. And that's why she didn't tell the police. She didn't talk about the open relationship with the police, and we've seen it from the various witnesses who were involved in this swinging, if you want to call it that. All of them, or a lot of them, were very guarded about their involvement in this type of relationship. A lot of that probably had to do with we have TV cameras in here filming everything that's being said, and they're worried about their image in the public and public perception of who they are and their morality. Knowing that, is there any doubt in your mind that that would be a consideration Sabrina would have when talking to the police about her and her husband's relationship? She didn't want to disclose her sexual life to the police. And despite testimony, we all know this is true. There is a double standard when it comes to men and women and views about sex. If a man is having a lot of sex, the view is, he's a stud. And believe me, I've heard this one all too often in a case relating directly to my client. If it's a woman, she's a slut or a whore. And how many times have we heard the term slut shaming? That is something that unfortunately we do in our society quite a bit. And that being exposed is not something that someone will want to do to anyone, to admit that openly. Is that also reasonable? Their view is that she's hiding her relationship with Jonathan Hearn and hiding her affair because they were conspiring. I gotta admit that's reasonable. Is it also reasonable Ms. Limon was trying to protect her image and the image of her husband by not admitting their relationship and the way their marriage was? She didn't want to sully her husband's name. Ever. Even on the stand, she admitted that Robert was a good man, and he was a good husband, and a good father. And that he loved his children, and he loved her. It doesn't mean he was a perfect man. None of us are. He was as flawed a human being as the rest of us. his demons he was dealing with also, as we all do. With regards to not telling the police about her affair with Jonathan Hearn, the prosecution's view is she's hiding this because she and Jonathan are conspiring to kill, and Jonathan killed her husband. You heard every one of those intercepts. You heard every one of those interviews. How many times did she say during those interviews with the police, it can't be him? No, that can't be true. It's not him. He wouldn't do that. She wanted to believe that Jonathan could not have done this. He was a firefighter. He was by all appearances, a man who had deep faith. How many times did we hear him praying on those intercepts? How many times in the text messages between the two of them did they talk about getting on your knees and praying and talking to God? She didn't believe that Jonathan was even capable of this. She didn't want to believe Jonathan was capable of this, to the point of almost deluding herself. She did truly believe that she loved Jonathan Hearn. That was before this plan by Jonathan Hearn to kill her husband ever evolved. He fulfilled a need in her, that something was lacking because that she and her husband had opened their marriage up. Had opened it. And she even said it. The sanctity of their relationship had been somewhat torn asunder when they opened their marriage up and began engaging in sexual activity with other couples, with other members of their group, including, as she put it, Kelly Bernatine, Jason Bernatine, and they even finally admitted it, even though they initially were denying any sex acts. Remember, it was a situation with Jason Bernatine where he said, well, we didn't have intercourse. Well, that leaves a whole lot of sex acts open that aren't necessarily directly intercourse. And he admitted that they did engage those activities, as did Kelly Bernatine. And she denied providing any photograph of her to Robert, but you'll have an evidence, the photographs off of Robert's phone that Detective Meyer found of not only her, but her friend and their friend, who was part of their adult group, Nancy. They were all on Rob's phone. Again, this is part of that adult group that they are involved in. Cell phone records they talked about. Prosecution view is it established their ongoing affair, and then on certain dates such as April 24th and 25th, May 23rd and August 17th, they were speaking or texting with each other. And that shows that they were communicating, and their communications were about killing Robert. But Mr. Smith, in showing you some of their communications in the month of April, to even Sabrina's home phone before Jonathan got her the cellular phone and gave it to her on April 25th, that they then used to communicate, they were constantly speaking with each other. You look at all the records and you'll see that their contacts were daily, whether it be text messages, whether it be phone calls. They were constantly contacting each other and speaking and texting. And I don't know about you, but I really, really hate texting when I'm using my phone. I hate it more than anything. I know that's the way people communicate now, but when you're texting, usually it's an ongoing conversation, back and forth. And you're usually fairly small snippets that you're really putting in there. It's not like you're writing a 20-page letter. So it's back and forth and commenting back and forth to each other. And Mr. Smith talked about all the text messages the day after Robert was killed that was sent and received between Sabrina and Jonathan. Was there any content where it said anything about Jonathan killing Robert? Or Sabrina knowing that he killed Robert? If there were, don't you think they'd have showed you those? There isn't. That was their normal communication. Something they did on a daily basis. Sabrina was struggling to deal with her husband's death, and the one anchor that she had to keep her and hold on to was her relationship with Jonathan Hearn. She was reaching for that. That's why she needed that. She was dependent upon him, much like she was when Robert was alive, dependent upon Robert. And Jonathan was the thing that was keeping her going. That relationship with him and those feelings she had for him. I mean, Mr. Smith talks about a normal widow's response to the death of her husband. I honestly don't know what that is. I know what Mr. Smith's view is, but I can't say what a normal response is going to be. Nobody can. Everybody responds in a different way to the loss of a loved one. And when you feel like you're drowning, sometimes you grab onto any life preserver you can. And you heard from her sister how she would be dealing with the kids, and all of a sudden she just collapsed on the kitchen floor and just started crying after Robert's death. You heard from her children that on the night that she was told Robert was killed, she collapsed on the front porch, was screaming and crying. These are the actions of someone who knows that their husband is going to be killed on that day? Or these are reactions of someone who's lost someone and is struggling to deal with that feeling of loss? And that person is gone. The person that kept them together, who was a part of their life, the father of her children, her husband, her primary support, her strength at home. Was their relationship perfect? No. I've been married for almost 38 years. I doubt if my wife would say I'm perfect. And if she did, I'd really be afraid. Is that evidence of consciousness of guilt? No. It's someone who's struggling to deal with the loss of a loved one. Yes, it is.
1:30. You're ready? 1:30. Remember not to form or express any opinion or discuss the case. See y'all back at 1:30.